Let me start by introducing our three speakers, or three sets of speakers. So the first paper is the Geopolitics and Law of the Eurasian Gas Market Integration, and this is presented by Shaimerden, Chikanayev, and Anatole Boute, both from the Chinese University of Hong Kong. The second paper is by Lesley-Anne Duvic-Paoli from King's, and it's entitled From Aspirational Politics to Soft Law, Exploring the International Legal Effects of Sustainable Development Goal 7 on Affordable and Clean Energy. And finally, we have Nina Araneta-Alana from the University of Melbourne, talking about climate finance and development in post-colonial Philippines. So the way all the speakers have 15 minutes, I'll keep stopwatch on everybody, and I'll give you a 2-minute warning if that's okay. And we will have the three papers running through, and then we'll take Q&A at the end. In terms of, there's just one small piece of housekeeping. If you want to ask a question, can I ask you not to use the hands up function, but rather to just put an asterisk in the chat. That way I can see the order in which people are asking their questions and I can call them in that order. So if you have an oral question, just put an asterisk in the chat. If you have a written question, because you're in a shared office or for some other reason you want to ask a written question, then again, asterisk and then just put your question in the chat. Okay, I don't know if there are any other questions or issues that I need to raise, if the speakers want to bring anything to my attention. Oh, I see that Shaimerden is just coming in now, so we will let her in. Anatole, are you happy to lead?
Yep.
Okay, well, thank you very much, Anatole, and please do commence.
Okay, wonderful, Navraj. Thanks a lot, and thank you all for for being here. So this is research on the law and geopolitics of the Eurasian Economic Union, and essentially, in a nutshell, what we are looking at in this paper is the strategic uses that Russia is making of treaties in its energy relations in Eurasia, and more specifically, the Eurasian Economic Union. So we're interested in strategic use of international law, international treaties. We'll focus on energy and the Eurasian.
Anatole, we've lost you temporarily.
Oh.
Yeah, you're back. You're back.
All right, sorry. I'm at university. The internet should be fine. I don't know what's going on. If not, I will switch off my camera. Let me know. So we're looking at strategic use of international energy treaties in the sphere of influence of Russia, and it's of broader relevance. I think it's important for the understanding of international energy law, a field that has often been examined from a European or Eurocentric perspective. So the theoretical framework that we're using first looks at the liberal versus geopolitical approaches to energy. This is mainly international political economy literature, not so much legal. And what we see is that energy security can be achieved from or through liberal mechanisms, the market at its center. The European Union is commonly used as an example of that approach. Prices are deregulated, the objective is competition, energy exchanges are created, non-discriminatory access is provided to the network, competitive and monopoly activities are separated, created, it's rule-based, and it's aiming at cooperating in the creation of an integrated market. And the literature often contrasts this liberal approach to Russia's geopolitical approach to energy. state-owned enterprises, in particular Gazprom, but also Rosneft, are used as arm of the state, as instruments of geopolitics. The state gives preferences to its allies through price discounts, and investments are made for strategic purposes, and also interruptions of supply can be threatened in order to obtain certain geopolitical advantages. So this is a simplification of the literature on liberal and geopolitical approaches, with the EU and Russia often used to illustrate both approaches. Now, there is a problem with this literature, and that is that Russia is now working on the creation of an integrated rule-based gas market in the Eurasian Economic Union, or as part of the Eurasian Economic Union, this economic integration project covering Russia, Belarus, Kyrgyzstan, Armenia, Kyrgyzstan, Kazakhstan. So this is integration, market construction, and it's rule-based. How do you make that fit with Russia's geopolitical approach? So it's difficult to explain this development, this rule-based, international, integration-based development. So we're looking at, we're building on the literature on international law and sphere of influences. Now, there's not much specifically on international law in relation to spheres of influences, but you have, of course, you have the work of Carl Schmitt and Gross Reumer, and that work is, for instance, is discussed in quite some detail in Laurie Malkso's fantastic book on Russian approaches to international laws, many references to Carl Schmitt in relation to or in discussion of Russia's sphere of influence. You also have the discussion of Russia's sphere of influence by authors like Dmitry Trenin. And of course, you have a lot of literature on the contest, the competition between Europe and Russia in the shared neighborhood. That is, of course, also constituted of Eurasian countries, essentially. Now, spheres of influence can be defined as spheres where foreign powers are trying to exercise control over a certain territory, and where these same powers are trying to exclude others, so trying to exclude foreign interference. So that, I find that a very useful definition of that phenomenon. Another important theoretical strand is more recent work on trade and investment and how that can be used for strategic purposes. More generally, you have the work on imperialism and international law. More recently, you have work on state-owned enterprises as arm of the state and how SOEs then can struggle to access arbitration if they are used for strategic purposes. Now, building on that theoretical framework, we look at the treaties that Russia signed with its strategic partners in the Russian sphere of influence. And we take a historical perspective. We look at the very first treaties the Soviet Union signed with the socialist countries and the Comecon countries. So what you find here is, first of all, that international treaties have been very important in the development of this massive energy infrastructure, probably the biggest energy infrastructure in the world, certainly in the gas sector, linking Russia's massive reserves to the European countries through the satellites. Now, it's often not well understood that international treaties were actually used to build that infrastructure, and it's very rarely discussed in the energy law literature. In fact, the Soviet Union and its Comecon partners concluded transit treaties and gas supply agreements that were essentially investment-based in exchange of gas supplies at subsidized prices. The Comecon countries built transit pipelines and helped construct the gas infrastructure in the Soviet Union. So it's barter-based and it's subsidized. And that is, in a way, if you read the literature on energy in the Soviet Union and the Cold War, energy was used as a bond. So subsidized price supplies were used to actually create this bond between the Soviet Union and its allies. It also had the objective of actually helping to exclude foreign interference. Of course, Western pipes and compressor technology was important and essential, but also there were embargoes. For instance, the Reagan imposed embargo on compressors, and the Soviet Union tried to protect itself from that by cooperating with its Comecon partners. And in fact, the infrastructure largely has been built using Soviet and Comecon resources, and that's very often ignored. And more importantly, the international law basis of that infrastructure, massive infrastructure, is often not discussed. Now, if we move in time and we look at more recent treaties, essentially the Comecon members became members of the European Union, at least some of them. And here, if there are treaties signed by Russia and these new EU member states, where Russia aims at actually excluding the application of European Union law, aiming at excluding the influence of the European Union on certain pipelines, for instance, the South Stream pipeline, through international agreements. Other very important and extremely interesting agreements are the agreements signed by Russia and the former Soviet states. Ukraine is a very fascinating example, but more relevant for present purposes. Belarus, Kyrgyzstan, Armenia, all three members of the Eurasian Economic Union, have signed in relatively recent years agreements with Russia in which they get access to cheap subsidized gas supply in exchange of giving up part of the gas infrastructure. In the case of Armenia and Kyrgyzstan, it's the entire gas system that is being given over to Gazprom. And so Gazprom is the investor, the foreign investor, acquires that infrastructure. In exchange, the countries commit not to implement market reforms. And market reforms that are actually EU-style reforms, like unbundling, diversification of supplies, these reforms are forbidden in the international treaty. And Gazprom can go to arbitration, investment arbitration, if the host government violates that commitment not to reform the market. So Gazprom is used essentially as an instrument to help enforce a commitment to exclude essentially EU regulatory influence. Now, what about the Eurasian Economic Union? So we're now we're referring to this project of economic integration driven by Russia essentially. And it has the Treaty on the Eurasian Economic Union has a gas title, a gas market integration objective. And very interestingly, that chapter includes a language that is close to the European Union model in a way. Creation of a competitive market, transition to market-based prices, creation of gas exchanges. But importantly, we're not speaking about full deregulation of prices, as you see in Europe. What the treaty refers to is the transition to actually export levels. So basically transitioning from subsidized prices to the level of prices paid by the European buyers. There is also in the treaty a reference to discounts, but we're no longer speaking of bilateral deals. The discount is multilateralized and institutionalized. In particular, the treaty commits Russia to exempt the export duty, and that's a huge discount. We're speaking about 30%. So what about control and exclusion? Well, price preferences have been given. So I should insist on that. In exchange of acceding to the Eurasian Economic Union, Armenia, for instance, has received significant price discounts in addition to the deal I've just discussed. And so Armenia was hesitant to either participate in the Eurasian Economic Union or join the association agreement with the EU. It eventually opted for the Eurasian Economic Union, having received this significant bilateral price preference. So in a way, bilateral preferences have been used to exclude association with the European Union and join the Eurasian Economic Union. Control. Well, here what we see is that the mechanism of
2
control,
minutes, Anatole, please.
Yeah, the mechanism of control is reduced through multilateralization of the export duty exemption. Russia no longer has the possibility to threaten to reduce the export duty because it's now in the treaty. Russia loses the possibility to manipulate prices because the treaty commits to increasing the prices to export parity. Similarly, if you look at third-party access, the cornerstone of market reform, it's a very important principle under European Union law. It's recognized in the Eurasian Economic Union Treaty, but the treaty at the same time includes a major exception. Vertically integrated gas entities do not have to be treated equally to other suppliers or market players. So this enables Gazprom to continue to maintain its monopoly, its export monopoly, and therefore its influence in the region, in the regional market. So let me conclude. Energy treaties have played a very important role in securing Russian influence in its sphere of special interest through subsidized gas supplies, and this has been clearly formalized in the treaty, through infrastructure investments, and by excluding European influence explicitly in the treaty, commitments not to reform and enforcing these commitments through investment arbitration. The Eurasian Economic Union follows to some extent that pattern, exclusion of European association by joining the Eurasian Economic Union in exchange of price preferences and preserving the monopoly of Gazprom as arm of the state. At the same time, Russia had to give up something through multilateralization of the pricing regime and the export duty exemption. This analysis, I believe, has broader implications. It gives a clear example of how international treaties can be used for strategic purposes and raises fundamental questions, for instance, for international investment law. Are strategic investments protected? Can Gazprom bring a claim to arbitration on the basis of this arrangement, on the basis of these geopolitical deals formalized into international law? Are these differences in treatment in pricing regimes acceptable under international trade law? And it tells us a lot about the potential geopolitical nature of regional economic integration regimes. Now, also, it is important from a climate change perspective and energy transition. We are speaking here of some of the most energy intensive and inefficient economies in the world. And one of the major reasons they are so energy intensive is because they have been fueled with subsidized energy supplies. This has helped to secure the dependence on Russian gas, but clearly contradicting the necessity to implement energy transition measures. Thank you very much.
Thank you very much, Anatole. That was great. Right, let's go straight to Leslie-Anne. I'm not sure if you have slides, Leslie-Anne, or if... Nope, okay, well, go shoot.
Enough screen time for us, so I'll do without PowerPoints. So thank you so much. My paper today is going to be about Sustainable Development Goal 7 on affordable and clean energy, and I'll be talking a bit about the international legal effect of SDG 7. So as we know, the 2030 Agenda for Sustainable Development consists in a compilation of goals and targets that represent a plan of action that has been agreed by the international community to end poverty, protect the environment, and ensure peace and prosperity. Among these goals, we have Sustainable Development Goal 7 that aims to, 1, ensure universal access to affordable, reliable, and modern energy services. 2, to increase substantially the share of renewable energy in the global energy mix. And 3, to double the global rate of improvement in energy efficiency. The adoption of this goal has been praised for being a major development in the global landscape of energy law and policy. the SDG is actually framing the international community's response to both the poverty crisis and the climate emergency. It seeks to remedy the fact that 2.8 billion people do not have access to clean fuels and technologies for cooking, and around 800 million people live without electricity. At the same time, it aims to make a significant contribution to the reduction of greenhouse gas emissions. What I'm interested in today is what is the relationship between Sustainable Development Goal 7 and international law. What is the normative status of SDG 7? The SDGs have been described as aspirational, and their fulfillment is generally acknowledged to be a political rather than a legal matter. 5 years after the adoption of the SDGs, we see that an actual evaluation of the international normative impacts of the adoption of a common energy objective remains lacking. So today, I'd like to provide a legal and perhaps paralegal analysis of an SDG that remains rather unexplored in the scholarship. And I also aim to provide an analytical framework to evaluate the transformational role of the SDG in governing the clean energy transition. So first of all, I'll be talking a little bit about the normative values of the SDGs, presenting them as political aspirations, characteristic of goal setting as a new form of governance, and I will then say a few words about the origins and crystallization of the goal to better understand its place in existing multilateral efforts to govern the energy sector. And that then I will try and propose a taxonomy of normative impacts that, if fulfilled, could qualify the SDG as a soft law instrument. Of course, I understand that the term soft law in itself is rather controversial and has been the subject of multiple scholarly debates. But here I'm using the term to highlight the legal relevance of a non-binding instrument and its role in shaping existing international law and contributing to its development. So first of all, what is actually the legal status of SDG 7? If we start looking at the literature on the SDGs, we see that the assessments of the legal nature of the SDGs tend to vary significantly and will depend on how scholars conceptualize law and non-law and the dichotomy between what is law and what is not considered to be law. Some authors have argued that the SDGs carry no normative value. Others believe that it is actually that Sustainable Development Goals are soft law, and others consider that they are at the softest end of soft law. What is clear is that the SDGs were initially viewed as political aspirations without normative potential, and this is what we see in the resolution of the UN General Assembly that adopted the SDGs, and what we also saw from the very beginning of the negotiations with the Rio +20 outcome document that was also talking about aspirational goals. So what we see is that during the negotiations of the SDGs, really, and even after, the legal force of the 2030 agenda was completely left unaddressed. It was not even mentioned, even to be denied or left aside. And it's quite instructive if you look at previous experiences of negotiating international development strategies, that in previous circumstances, in previous cases, actually the question of the legality of programmatic resolutions was very much discussed. So in the 70s, for instance, when the UN adopted its second development decade and its strategy for that decade, there was a lot of discussion about whether this strategy was law or could have legal effect or not. Even if we look at the Millennium Development Goals, the MDGs, there are significant number of scholars that have actually argued that they now represent customary international law. But today we consider that the programmatic nature of the SDGs is really an alternative to international law that has been perceived to be deficient because it has been unable to put states on the path to sustainable development in the past decade. So we consider that this goal setting exercise that we've been doing is an alternative method of international and multilateral cooperation. And this is, of course, particularly well suited in the context of energy governance, because this governance tends to remain rather weak, with states giving priority to energy security concerns and their rights to exploit their own natural resources. So what is the role that SDG 7 actually plays in the existing international legal framework? Well, we can argue that the goal does not really bring about a legal revolution. It is just the changes that it's encouraging is actually rather minimal. So it's fairly consistent with the role played by international cooperation in governing the energy sector before the adoption of a 2030 agenda. It is, of course, noticeable that we now have a standalone goal on energy that was absent in the MDGs. And this is because the question of the role that energy was playing in sustainable development was very controversial until recently. But we can see that now, and I won't go through the whole history and the origins of SDG 7, but what we can see is basically that SDG 7 actually replicates the targets of the Sustainable Energy for All initiative, and as a result, it reinforces existing forms of cooperation with two main changes. We can say, first of all, we're moving the goals of a Sustainable Energy for All initiative from technical obligations and technical objectives to more legal or paralegal commitments, and we are framing those goals within broader sustainability challenges and concerns. So there are more opportunities to link energy matters with other governance, natural resource governance issues, and more opportunities to think about the relationship between SDG 7 and other SDGs, such as the SDG on food or on water. So what kind of normative legal effects can we say that SDG 7 it has had or can have in the future? And I'll be talking about three different kinds of effect on the international legal order, on international treaty law, and on international customary law. So first of all, I'll start with broadly the international legal order, because this is what the scholarship has been mostly interested in, with an argument that the SDGs tend to orchestrate all existing regimes that will align with the agenda. And SDG 7 has been called a meta-norm that would actually influence relevant international institutions and change their political and legal agenda. What we see with SDG 7 is that it seems to have been the case, but it's not always the case, and that there are certain institutions, in particular in the field of trade, that have not really integrated the objectives of Sustainable Development Goal 7. So we see, for instance, that the goal tends to operate in a trade vacuum, especially when we compare it with other goals that are very much more trade focused, such as the goal on agricultural markets or on fisheries subsidies. When the goal has actually had an influence, often we see that this influence is often minimal. It has influenced the role and the place of certain initiatives, including, of course, the Sustainable Energy for All initiative, but also the RISE indicators of the World Bank. But the role that the work that those institutions were actually carrying out has not changed significantly. It's more about how the institutions have portrayed their place within the objectives of the international community more broadly. What is perhaps more interesting is to look at how the SDG can help develop international treaty law. First of all, I think it's important to look at the interactions between SDG 7 and the Paris Agreement, given that they're often mentioned as an ensemble and that their objectives are very complementary. I think the question that arises is whether SDG 7 can have a direct legal impact on the Paris Agreement, and what this would mean for the goal in terms of its normativity. It's quite complex because actually SDG 7 operates in close conjunction with the Paris Agreement, but parties have not necessarily made a close, at least explicitly, a close relationship between the process with under the SDGs and the voluntary national review process and their work under the Paris Agreement and nationally determined contributions. But if we look at the potential for including the objectives of SDG 7 under the NDCs, we see here that this is quite interesting, given that, of course, the energy sector is a major source of emission, and also given the fact that states will not be able to downgrade their existing NDCs and will have to submit increasingly ambitious commitments every 5 years, there's a potential to actually integrate those objectives of the SDG 7 into the work being done within the NDC process. We can also say that SDG 7 can be seen as a precursor to international treaty law, not so much in terms of adopting a new treaty that would implement one of the targets or all of the targets of SDG 7, as it has been discussed by the scholarship, as it seems to be fairly something that will be fairly difficult to achieve. But we can see that SDG 7 has been integrated in a number of international trade and investments agreements that were adopted after 2015, in particular in the preambles of those treaties, but also that there's been a role for SDG 7 in driving the work, the ongoing work on the modernization of the Energy Charter Treaty, with parties explicitly referencing SDG 7 as one of the driving factors for this ongoing modernization process. What we see as well is that SDG 7 has also played a role in some of the work program of certain treaties. For instance, the Convention on the Conservation of Migratory Species of Wild Animals has been driven by SDG 7 to look at the impacts of renewable energies for migratory species, and other treaties in their decision of the parties have also referenced either SDG 7 or more broadly the SDGs as a contextual element for their new work programs. SDG 7 could also play a role in norm interpretation, and in particular in helping define the contours of the vague concept of sustainable development. The MDGs have been used in the past to actually help with the interpretation of the concept of sustainable development. And we see, not yet at the international level, but at the domestic level, a number of courts using the SDGs, and in particular SDG 7, to help with this interpretation of what it means to actually implement a sustainable development approach in relation to the energy sector. And finally, my last point is about the contribution that SDG 7 could play with regards to the emergence of a human right to energy. And here it becomes perhaps more complicated. Is there a role for the practice that is emerging from trying to meet SDG 7 in the contribution of the emergence of either custom or an explicit recognition of the right to energy, as it has been done in the past in relation to water? What kind of role will this kind of mobilization of the international community play in relation to the right to energy? This is something that will be interesting to look at in the future. So to conclude, I think we can really see that SDG 7 remains a political aspiration, that it's very much an ambitious objective, perhaps even unachievable, and a kind of hopeful vision to transform the global energy landscape. But this does not mean that it will remain only within the political realm. We see that goal setting does not preclude the creation of legal effects, and that SDG 7 can act as a complement to or as an inspiration for existing or new legal norms. Thank you.
Thank you, Leslie-Anne. That was great. And let's move straight on to Nina.
Hi, thank you. I'll just share my screen. Okay. So good morning, everyone. My name is Nina, and I'm zooming in from Melbourne, Australia. So before I begin, I acknowledge the traditional owners of the land on where I am physically located, the Wurundjeri people of the Kulin Nations. I pay respect to their elders, past, present, and emerging. I recognize that this is unceded land and that the traditional owners have a continuing connection to land, waters, and culture. So thank you to the organizers for pushing through with this conference despite all the challenges it faces today. It's been a wonderful opportunity to learn from each other. My presentation this morning is on climate finance and development in post-colonial Philippines. I started thinking about the topic of climate finance when I was working as a transactional counsel on renewable energy projects in the Philippines. I observed that renewable energy projects involve mostly the elite of Philippine industry and society to whom banks were eager to lend. I then thought about how in the Philippines, the national climate change response centered around the renewable energy industries. And I thought about how so few resources went into other climate-related projects that did not have the same returns as renewable energy projects, such as adaptation of vulnerable communities. I then started to think, why was the Philippines one of the most vulnerable nations to climate change, not conversing in a language that emphasized both mitigation and adaptation outcomes? Why was climate finance being used largely to further existing structures of power in society that benefit the elite? Is there something about the Philippines' colonial history? So the Philippines was a colony for more than 400 years, first under Spain from 1521 to 1898, then under the US from 1898 to 1945, briefly under Japan during the Japanese invasion during World War II. So I thought about whether that would reveal more about its current situation. These were the thoughts that impelled me to undertake this research project on climate finance in the Philippines. And ultimately to my research question, what does the Philippine response to climate change tell us about how climate finance takes form on the ground and stabilizes in meaning? So I used two main methods in my inquiry. First is doctrinal research, which includes the methods of textual analysis, practical argumentation, and principled or structured reasoning, and institutional legal historiography. This method of institutional legal historiography has been attended to by critical analysis, particularly critical redescription. So Sancho Pahuja says that critical redescription is an attempt to redefine through narrative a world we take for granted, inviting it to be seen differently as a mode of political engagement. So what have I found thus far? First is that we have to be attentive to the historic responsibility of states in terms of greenhouse gas emissions. So the Rio Earth Summit in 1992 marked the first international political response to climate change. Under Principle 7 of the Rio Declaration, developed countries acknowledged that their societies, as well as the technologies and financial resources they commanded, put pressures on the global environment. So under Principle 7, it states there that states have common but differentiated responsibilities. So this is the CBDR. They also acknowledge that they bear responsibility in terms of, they have the international pursuit of development. They put pressures and societies, their societies put pressures on the global environment in terms of the technologies and financial resources they command. So historically, developed countries are responsible for greenhouse gas emissions. The UNFCCC, or the United Nations Framework Convention on Climate Change, is based explicitly on the concept of common but differentiated responsibilities and respective capabilities. So recognizing their responsibilities and capacity, developed countries agreed to provide financial resources, including the transfer of technology, to assist developing countries and enable them to meet the costs of adaptation and reduce greenhouse gas emissions. The term climate finance is thus a creation of international law, but its meaning is unfixed. So despite its constant usage, climate finance has not been formally defined in any international treaty. In the UNFCCC and in the Kyoto Protocol, we see that developed countries agreed to provide financial resources, including the transfer of technology to developing countries. So this was required under the UNFCCC and the Kyoto Protocol. So in the Kyoto Protocol, there was this general sense of the notion of equity, and it's embodied in the concept of common but differentiated responsibilities. And this underpinned the commitments and obligations of the states under law. And ultimately, it reflected the spirit and principle of, Principle 7 of the Rio Declaration. But what happened after the adoption of the Kyoto Protocol? So after the Kyoto Protocol came 2 decades of the conferences of parties, meetings, and decisions. So the conferences of parties, or COPs, play a role in international lawmaking. COPs are institutions established to give operative effect to treaties. As such, COP activities, decisions, agreements contribute to the legal obligations of the parties under formal treaty obligations and play a formative role in shaping the body of international law. So I would like to pay attention to 2 actions of the COPs. The first is the Bali Action Plan. It was adopted by COP 13, and it called for enhanced action on the provision of financial resources and adaptation, including the consideration of the mobilization of public and private sector funding and investment, and the facilitation of climate-friendly investment choices. So the Bali Action Plan, which was passed in 2007, sought options to generate resources such as tapping into private sector investments. It was in the 2009 Copenhagen Accord where this new idea of climate finance took full form. Under the Copenhagen Accord, developed countries committed to mobilizing $100 billion a year to address the needs of developing countries, and that such funding will come from a wide variety of sources, public and private, bilateral and multilateral, including alternative sources of finance. The Paris Agreement was adopted by consensus on December 12, 2015. Under the Paris Agreement, developed countries agreed to take the lead in mobilizing climate finance from a wide variety of sources. So this tracks the language of the Copenhagen Accord. In the year following the Paris Agreement, developed countries, including the United Kingdom and Australia, released a document entitled Roadmap to 100 Billion, which referred only to the meaning of climate finance as mobilized funds to address the need of developing countries in the context of meaningful mitigation actions. So we see here a shift in language from 1992, 1997, to 2009 and 2015. That is, the obligation of developed countries changed from providing to mobilizing. And then we think about how are the funds to be mobilized. So there's a growing interest in green economics, looking towards the private sector to fund the global response to climate change. But we have academics from the global south, such as Gichira, Aguata, and Mugwa, who have critiqued the privatization of climate finance and the perception of climate finance as a business opportunity. They see as problematic the advancement by developed countries of climate finance mechanisms impelled by profit incentives, and decry the fact that the funding of climate projects is being viewed as but another lucrative economic opportunity. Scholars such as Beatriz Felipe Perez have criticized the meaning of climate finance that was adopted in the Paris Agreement on the ground that such meaning has diluted the responsibilities of developed countries. As such, we have come to understand that the meaning of climate finance itself is a space for contestation. Different actors compete to advance diverging views on climate finance. voices from developing countries insist that the meaning of climate finance should be a form of redress or equity, and this should be retained. Another meaning of climate finance, one of mobilized funds, investments, and private sector participation, is being advanced by developed countries. In a contested space with the plurality of actors behind competing political projects, how does one meaning emerge as dominant over others? It is in this contested space that I looked at climate finance in practice. In what form does the funding of climate projects take place? What resources actually go into the developing nation state? So it's a question of distribution. I have reviewed the funding that has actually gone into the Philippines and have found that in practice, the idea of providing financial resources has taken shape largely as debt. I also found that there is a bias towards mitigation. Multilateral development institutions such as the World Bank and the Asian Development Bank have become central to the translation of climate finance from the international to the local sphere. In the Philippines, these development institutions have become a conduit for climate finance and for significant levels of funding of climate projects. These institutions have also generated expertise and created knowledge on how climate finance should operate. As can be seen through case studies of climate finance projects in the Philippines, there is a coupling of objectives of development and environment. Climate projects are underpinned by the aims of privatization and global trade. The creation of the Philippine renewable industry was underpinned by a Western-led development project that used debt to shape an industry into one that is privatized and liberalized. The interventions of climate funds and climate bonds in the Philippines stabilized the development trajectory of energy privatization and the privileging of private capital in the climate space. On the other hand, there are climate adaptation, but these strategies are actually being pursued to ensure the resiliency of the production base and enable the Philippines to develop value chain commodities. So here we have trade. The project was aimed to secure the global food supply chain first and foremost. It's framed as necessary to attain this objective. So the post-colony is an arena where the contestation plays out. In the Philippines, we see how the operation and translation of international climate finance interacts with existing legal and political economic power structures, many inherited from the Philippines' colonial past. In my research, I unpack the imperial parallels in how climate finance has been adopted in the Philippines with earlier imperial modes of governance. The parallels are evident in the deference or submission to an external authority. So these are the multilateral development institutions, and the reproduction of historically constructed social hierarchies. We see how climate finance, instead of being redistributive, echoes the patterns of the development project and replicates debt as its primary mechanism. As a last note, I ruminate upon the significance of my findings. Why does it matter? Of course, we are all familiar with the perennial so what question, that we all had to encounter at one point or another, and which we continue to encounter, of course, in our work. There are broader implications in this research project. One is that it reveals that the nation state's role in the climate space is diminished at the same time that private interests are given more attention. From an ontological perspective, it shows how international law becomes translated on the ground in the nation state. In terms of accountability, an important question arises as to who does the public hold accountable for the failure to meet climate targets when the activities and results are driven by the market? Can climate finance really be a way forward in the global climate change response when it is so deeply intertwined with the neoliberal and imperial story? So that's where I'd like to end for this morning, and I look forward to hearing your comments and questions.
Thank you so much. That was fantastic. Really enjoyed all three presentations. I have some questions of my own, but I would much rather hear from the floor, as it were. So, does anybody want to get us started? Okay, while people are formulating their own questions, let me just ask one quick question to each of our speakers. So, in order, Anatole, so this liberal geopolitical framing, you know, when you put them up, I wondered if these approaches are actually mutually exclusive. You know, it strikes me that one could easily define the liberal enterprise as a deeply geopolitical one, and you know, the European energy market is a great example of that. And if that's the case, is it any surprise that in the Russian approach, as you map it out, that we find that it has elements of both liberal and geopolitical of those framings? To Leslie Ann, just really asking, I suppose, a temporal question, which is, you know, in the context of climate change, say, and the 1.5 degree report and the time frames that we have, you know, what does a pathway for SDG 7 look like in order to make a meaningful contribution? And then to Nina, you know, I think, you know, in climate debates generally, we know that adaptation is the poor cousin of climate action. In terms of mitigation, we know that renewables dominate because, you know, they provide a meaningful return on investment for investors. We know that adaptation lacks business models, which, you know, limits the amount of the contribution that they currently make. But these are all generic features. You know, these are generic features. These apply practically everywhere. So what's distinctive in this discussion about post-colonial polities and/or the Philippines in particular? Should we take those in order? Unless.
All right. Thank you, Navraj. So that's a very good point. You could indeed argue that the European Union energy market is built on a geopolitical basis, the market itself, and even more fundamentally, the objective of competition, of market integration. It's a way of responding to the Russian threat in a way. I find that a very interesting argument, and but I think it means that actually the law, the European Union energy law, in a way is also geopolitical, and this, in my view, has significant consequences. Which, if your point is correct, and I think it is actually, and I think it would be worth, you know, arguing and setting that out more in more detail. The point you make, I think, deserves you know, a legal analysis to explain the way geopolitics is actually embedded in the regulation of the European Union market that is usually presented as a liberal, market-friendly, competitive project. So if it's actually a geopolitical initiative, then there are consequences to that, and there are indeed consequences to that, and we see that very clearly before the World Trade Organization, where Russia is bringing a claim against the European Union, saying, well, you know, the way you're applying your laws is actually discriminatory. And yes, it is, because it's actually geopolitical. But the European Union doesn't perceive it that way. The European Union finds market justifications. The same with the claim brought by Nord Stream 2 against the European Union, presenting the extension of the scope of the gas directive as discrimination. And I would say, yes, it is, because it is indeed a geopolitically driven measure. So the point you're making actually is extremely important. I don't think it has been formulated clearly enough in the energy law literature. I'm actually planning to write on that, because I think it's extremely important. And now, but again, it has to be explained. But then, so if you look at it from the Russian perspective, the Russian perspective It's again, as you're right, it's the interaction between liberal approaches and geopolitics. It's more pronounced, it's much less market friendly, it's more state driven. The strategic dimension is clearer, but clearly looking at the European Union approach and the Russian approach side by side helps us to put into perspective the concept of liberal and geopolitical and explain the interactions and understand the interactions. I haven't done that comparison. I've just limited myself to briefly review the literature, but it would certainly be worth explaining that actually the differences are not that fundamental. I just don't want to conclude one more point, and that is that what I think is very important is the Russian approach to international energy law, and I think there has been almost no insufficient attention to that. And Nina, I like.
We lost you just when you were about to praise Nina, sadly. Leslie Ann, do you mind stepping in? And if Anatole comes, are you back? Yeah.
Okay.
Oh, there you're back. Anatole, we lost you when you were saying what you liked about Nina's paper, and then you cut out.
Yeah, I'm really sorry. This is very unusual. I don't know what's going on. I just wanted to say that the approach, looking at the Philippines in relation to international climate law, international climate finance is extremely important. I think we need more of these national approaches to international regulation. And the Russian case is extremely fascinating for energy markets. And in fact, energy transitions and understanding what is going wrong here. It's actually also post-imperialistic in a way. And unfortunately, the literature is so much focused, on the Energy Charter Treaty and on very much, the usual suspects. I think we need more of these national approaches to international energy law, international climate law. I think this helps us to find out about many interesting mechanisms. Thank you.
Thank you, Anatole. Thank you very much. Leslie Ann.
Thank you. Yes, so the question of what is the pathway for SDG 7 to actually make a meaningful contribution to the fight against climate change, and that's a very important and interesting question. And the answer is perhaps not so positive. So I mean, if we look at the review that was undertaken in 2018 of SDG 7, really the conclusion was, well, there's a lot of action, but it's not going to be enough to actually meet the targets by 2030. And basically the targets of SDG 7s are basically more or less temporally speaking, aligned with the objectives of the Paris Agreement, given that we know that we more or less have until 2030 to really mobilize if we want to meet the 1.5 degree. At present, the idea is that what states have been doing a fair amount to try and implement SDG 7, but if they continue the way they have, it's not going to be enough. And of course, this was before the pandemic, and it might go two ways. Either it might accelerate the action that had started beforehand, or it might actually impede it. And it's, I think, still fairly uncertain which way we're going to go here. I think the question also kind of raises the question of a temporality of lawmaking, and whether actually we're going fast enough when we look at the emergency the urgency of the situation. And I think here we know that lawmaking is quite a slow process, be it in international negotiations or the creation of customary law, etc. This takes quite a fair long time. So is that just going to be enough to actually meet our targets? That's probably unlikely. I think the more positive aspects of it is that the SDGs, and also then the kind of lawmaking process that derives from it is making sure that they remain on the table, that they are on the agenda, that there's a plan of action, and that states and other actors are mobilized, so it might facilitate the objectives that we have, but I don't see it as being kind of the only answer to the crisis that we have today.
Thank you very much. And to Nina.
Thanks, Navraj, for that question. So what's distinctive about the post-colonial experience of the Philippines? How does it relate to its climate change response? So what I would like to emphasize is that the colonial history and the colonial relations of the Philippines cannot be divorced from an understanding of its climate change response. So we have, for example, the renewable energy industry, but how was it created? So if you look at the history of the energy industry and the renewable energy industry, you can see that debt by the Philippine government, it plays such a large role in the creation, the current status of the energy situation in the Philippines. So that has long underpinned the creation of the energy industry. There's a long history of US lending to the Philippines, for example, that has ultimately caused the liberalization of the energy industry. So there's also a capitulation to the development project. And when you think about adaptation, what I found is that adaptation and trade are being closely linked together. So there are adaptation projects in the Philippines, but it's primarily, the goal is to protect trade, international trade. The role of the Philippines as a supplier of raw material in the global supply chain. So this should be protected. And this echoes a colonial story of extraction.
Thank you, Nina. That was great. I've got a question from Gigi and also a nice comment from YMH. But Gigi.
Thank you. I always feel bad stepping in first as one of the organizers, but as it seems to be silent. So I really enjoyed all the presentations. I do think it's fantastic that we do have a full spread of kind of talking about gas and then energy and then climate action. So I have a few questions about SDGs for both Anatole and Glasginburgh, and then for Nina about privatization. Okay, so maybe for Glasginburgh, if I can start there. So in my experience, energy transition, I suppose we can call it an energy transition goal, but access to energy goal crowds out sometimes the climate goal in funding landscape. So I wanted to hear your input on that. I think you've been talking about it as a positive development, but is it entirely, or is it doing something else that maybe we don't want it to do? For Anatole, then kind of flipping that question a little bit, is there actually any sign of Russia paying attention to SDGs? Because it's supposed to be universal, but I think it's very interesting to have this reality check that you gave us. Okay, we can talk all we want about renewable energy, but you know, this is happening in Eurasia. So I suppose then the obvious question is, so do we have any influence of SDGs in the region? And do you think it matters for Russia at all? Does it feature in these formalized new mode of agreement at all? And then for Nina about privatization. So I'm fascinated by the privatization trend that has taken place in the renewable energy sector as well. However, in the recent research, we have heard this counter argument that I really wanted to hear your opinion on, that if we do renewable energy through grants, so if we don't do privatization, then we will basically create the same kind of dependency that was there before kind of aid instead of trade movement started, right? So the initial story of development is that we give aid and then that creates dependency. So the argument for privatization is that it reduces dependencies. I would be very interested to hear whether you think that's, what do you think about that argument? And also maybe just a related question about the power grid, because I feel that renewable energy still has, it's not a thing that private companies do themselves. They still need access to power grid in order to execute these projects, and they still need, permission by the government to be there. So I sometimes wonder to what extent when we talk about privatization, we let off governments too easily. And we say that, okay, they are no longer the main actor, but they're still necessary because energy mix and power grids, they're still nationalized. So yeah, just a few reflections. Thank you.
Thank you very much. Leslie-Anne, you've unmuted yourself. Go ahead.
Thank you. So yes, I mean, I think it's an important question. We see that there are actually tensions within the targets of SDG 7 between, on the one hand, access to energy and then renewable energy expansion and energy efficiency. And it's interesting that those tensions that are quite evident are never actually acknowledged by the official discourses of the international community. And if you look at reports on SDG 7, really the emphasis is always on the fact that that they are all intertwined, interlinked, and that they are complementary objectives. So there's very much a narrative that kind of tries to counter the actually reality of the fact that it might be difficult to actually meet the energy access objective while at the same time reducing emissions. And actually, if you look at one of the decisions that has reference SDG 7 in so a domestic judicial decision from a Kenyan tribunal. In there, the tribunal actually used the SDG to rule on the legality of Kenya's first coal-fired power plant. So the SDGs there were used to actually justify the fact that sustainable development should not be understood as as prioritizing the environmental pillar of sustainable development, but that also the social and economic considerations had to be taken into account. So I completely agree with you that it's going to be fairly difficult to actually manage those different tensions. And something that is also important to look at is the fact that there will also be tensions between the SDG 7 on energy and other SDGs on food or on water. Just focusing on renewable energy might have an impact on food security or on water security. And so the interactions and the kind of conflicts between the different SDGs is often overlooked by for kind of narratives of the international community.
Anatole.
Yes. Russia is working on renewables, and are trying to develop renewables. They have a support mechanism in place, and now they've just adopted the one chamber, the Duma has just adopted the law on emissions trading, but it's it's more project-based emission reductions rather than a proper emissions trading scheme. So I mean, of course, a lot needs to be done there. I'm in this paper more interested in the impact that treaties have on the region, on the neighbors, and so the neighbor, yeah, I mean, Ukraine is a very interesting case because they've now basically stopped their gas relation, with the exception of transit, and with Russia. And as a result, you've seen a huge increase in, reduction in energy intensity of the economy, and very much now the urgency of energy efficiency improvements. That becomes really kind of a huge priority. And what they should have been doing, what they should have done over the last 20, 30 years, well, they're only doing it now. Why? Because the geopolitical relation with Russia has collapsed essentially, and that's great for the environment, you might say. It's great for their energy security, and so in a way, really, I think it's really important to understand what is preventing the energy transition. And clearly, in that particular region, access to subsidized energy fuels is a major obstacle. And of course, there is also corruption associated to that, and the elite has benefited from the deals with Gazprom and had no interest in reducing the energy intensity of the economy. But it's important to understand the mechanisms that are preventing the transition before, and actually including international law mechanisms. Now, this is not universal international, it's regional international, regional agreements. These are still treaties. Some of them are actually international economic law related, investment, in fact, investment agreements, investment protection agreements, specific to the energy sector. The Energy Charter Treaty is certainly not the only energy specific investment protection treaty. If you look at the bilateral agreement between Armenia and Russia, Kyrgyzstan and Russia, Belarus and Russia, these agreements, based on these agreements, Gazprom takes over the gas system or parts of it in exchange of subsidized gas supplies. They commit not to reform the market, and Gazprom can go to arbitration if anything happens that interferes with their rights. And I mean, that is a clear constraint to the reform of these markets towards sustainability, I think. And it's international energy law. It has to be discussed.
Anatole, did you want to come back to Gigi on her second point about the impact of SDGs in Russian law and policy making in this sector?
Oh yeah, but sorry, I thought I answered that more or less. But the point is, I don't know exactly the extent to which the SDGs are having an impact. I'm just saying they are indeed working on renewables, working on emissions trading. It's not. I don't think it's in reaction to SDGs. The emissions trading scheme is a direct reaction to the EU carbon border adjustment mechanism. That's it's also in a way it's geopolitics. It's the EU using carbon trading as a tool, yeah. But it's not SDGs. I'm not that I'm aware of. No.
Thank you. Okay, on to you, Nina.
Thanks, Gigi, for that question. So yes, of course, there is this debate on how should financial resources be given, aid, grant, debt. But I would like to posit that an eye has to be cast to the post-colonial nation state. And when you have privatization, you have to slow down the story and think about who are really benefiting from privatization. And if you look at the colonial history of the Philippines, you can see now that the companies, the families actually who hold power and who hold influence in the Philippines, that they did so because they benefited from the colonial history of the Philippines, the colonial relations they had with Spain, with the US. And so my intention here is to really tease out those connections and to really unpack that it's not all the power, the money, these are concentrated in the hands of a few families. And it's because of that colonial history of the Philippines that's happening. And when you have that happening, I wanted also to tease out what is happening in the nation state. Like, is it really the Philippines as a nation state? What is its role in the climate change response? Is its role being diminished? And I think that's what's happening right now, even in terms of the grid. You mentioned that the grid is nationalized. In the Philippines, for example, the grid is privatized. And it's also because of, it was a result of so much debt being held by the Philippine government that it had to sell the grid. And there's even a new story there unfolding because China has bought into the grid of the Philippines. So there's a new story unfolding, unfortunately beyond my research project, because that will take me so many years to finish. But there is also this new element here wherein you have a new geopolitical forces coming into the Philippines. So it's really that story, the elements are there for that story.
Thanks for that. I don't know if you want to come back to that, Gigi, or to any of those points, but if not, I would. But in any case, I would invite other colleagues to ask questions if they have any. No. If there are no questions,
I have a question for Nina, if I may.
yeah, go ahead, Anatole.
Sorry, I didn't find the starting. Nina, how do you see the Belt and Roads impacting on essentially climate finance or basically the energy transition in the Philippines? So do you see many investments made in carbon-intensive projects, or do you see China investing in, or Chinese companies investing in sustainable projects? And what about lending? Because lending is a big thing. I mean, you're interested in debt, but that's clearly one of the key things, right, with the Belt and Road. So how does that relate to your story? I think it's very important. I mean, it's fascinating what you're saying.
Yeah. Thanks for that, Anatole. Actually, there's so much. This topic has so many moving parts. So much. In terms of China coming into the Philippines. So well, we're not part of the Belt and Road specifically, but you can say that we are in a way because the Philippine government, for example, the current Philippine government is a very friendly towards China. It has borrowed a lot from China, mostly towards infrastructure. So the current priorities of the current administration is not on sustainable development, but more of infrastructure. These are building of highways, building of roads. But you can see that the relationship there between the current administration and China is strong. And it's very, it's politically motivated, of course, because in terms of trade, in terms of access to waters, in terms of islands, if you're aware that there was an arbitration case between Philippines and China, wherein they were disputing the islands in the West Philippine Sea or South China Sea. And so there is so much to unpack there in terms of you have, these big, powerful nations using debt as leverage in terms of, getting a foothold in terms of what they want. It just so happened that the current administration, climate change action is not their priority, but they are borrowing a lot from China in terms of infrastructure building.
Thank you, Nina. If Anatole doesn't want to come back on that, I might ask an additional question. Sorry to bombard you, Nina, but you've obviously got a lovely topic. Just wanted to ask about this issue of the distinctiveness of the Philippines. A lot of what you say about the concentration of the energy sector or the economy more generally in the Philippines is very common in jurisdictions which share the socioeconomic indicators or similarly situated to the Philippines. But of course, the Philippines has got this unique combination of it in its colonial history, and in particular as a mixed jurisdiction. And I wonder, does that mixed jurisdiction, or its mixed legal system, rather, have any particularly distinctive features for your topic that would distinguish it from, say, Laos or Thailand or even South Korea, which in many ways, although economically very different, has many of the concentrated economic features that you described?
Yeah, so the Philippines is a mix of civil law and common law. Is that what you're pertaining to? And so we do have a civil law tradition. We also have a common law tradition because the Philippines was colonized by both Spain and the US. And in terms of, I think, like international law, like how does the Philippines view international law? I think that is where you can see, because it is a mixed, it has a mixed legal tradition. You can see the approach is also mixed. So we look at codes. We look at how 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 the law is written, but at the same time, there's also in the way that common law is established, or common law is created. We also look towards like practice, or we also look towards how other states have viewed things. And the Philippines, for example, our judiciary, our legal system, our Philippine legal system looks a lot towards the US, for example, in terms of, okay, so what does the US say? And there's this deference towards US court cases. And that really cannot be, you really cannot separate that from this history of the Philippines coming from both traditions in its very close relation with the US.
Okay, thank you very much. It's 9 minutes to, and I'm sure I'm not the only one who's got a meeting at 11 o'clock. So if there are no further questions, seems not, I will do the thank yous. So thank you very much to the organisers. I think you've done a really wonderful job in pulling all of this together. It's very complicated and it's been done very well. But of course, thanks above all to our three speakers, Leslie Ann, Nina and Anatole. I've really enjoyed your presentations, and looking forward to reading the final versions of these papers, all of which could spin off into a whole series of other papers and further papers. But it's three great research agendas there. So thanks very much, and take care.
Thank you all. Thanks a lot.
Bye.
Bye. Bye.
Bye.